You know the phrase, they made me an offer I couldn't refuse? Well, contrary to that phrase, they made me an offer I could and did refuse. You want to know what this is all about? Come join me for a walk through town as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, this is a medical malpractice case. The defense came to me telling me that they were ready to start negotiating. Now, it had been 2 years during the course of this litigation that they refused to accept responsibility. 2 years where they turned around and said, we will never, ever try and negotiate. We will see you at trial. So I said, fine, we'll see you at trial. Well, now, as we are approaching trial, the defense called me, the attorney called me, and he said, okay, we'd like to start negotiating. Are you willing to negotiate? Now, I'm always willing to talk. I'm always willing to listen. Doesn't mean we're going to get the case settled. Doesn't necessarily mean we're going to be successful. However, I'm always willing to listen. So now I felt this case had a value of $1 million. And the defense told me that they were eager to start negotiating. They thought that we had a good case, and now they come back with their first offer. And what's their first offer? $100,000. What did I do? I told them, no thanks, not interested. Have no interest whatsoever in negotiating further. Your offer clearly is insulting. Your offer clearly indicates you are not serious about trying to negotiate this case. Therefore, we'll see you at trial. Now, why would I do that? I'll tell you why. Because although the defense now recognized that they had a problem, although the defense now realized that they needed to settle this case, they clearly evidenced their intent and whether or not they were serious by making a horrible, horrible lowball settlement offer. They knew what the real value of this case was, but they were hoping to try and save a huge amount of money by starting negotiations at only $100,000. That was the wrong ballpark to be in. We weren't even in the same stratosphere, so that I could not even have an intelligent conversation with them about why we felt that this case should be settled and why we felt this case had a more significant value. Now, how do I know that the defense knew that this case had a much more significant value? I'll tell you how I knew. Because they had told me they had done a verdict search. They had told me that they had done an appellate search to evaluate the full extent of this type of injury, what similar cases have settled for, what similar cases have gone to verdict for, what appellate courts have upheld in the state and in this particular county. So I knew that they knew that this case had a much more significant value than what they were offering. Now, does that mean that they did not have more money to offer? No, that's not what it meant. And I knew that they had more money to offer. However, what I did know is that this attorney was relatively inexperienced, and I had never negotiated a case with him in the past, which meant to me that there was a lack of trust here. And that's a significant problem when trying to negotiate a case, especially when you have no idea whether or not the attorney has full authority to settle the case, whether he's got sufficient authority to go ahead and get more money if needed to settle the case. My impression was that he did not have significant authority to try and settle, nor did he have the authority to go get additional money if it was going to go ahead and settle this case. So, from the outset, when he offered $100,000, did I say that was an offer I couldn't refuse? No, just the opposite. I told him I'm sorry and I thank you for the offer, but that offer is horribly inadequate, it is insulting, and we will have no further discussions. I will see you at trial. So why do I share this information with you? I share it with you hopefully to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and are thinking about bringing a case, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.